As a court pleases your worship, I'm ready to proceed. I'm indebted to the court's indulgence in having a comfort break. Your worship, I think I've got 3 legal points that I'm going to present, and then I'll conclude. Your worship, in as far as Section 64B is concerned, your worship will notice that this is the bigger part of the submissions sharply focuses on Section 60 subsection 4B, because from the opposition one picked it up that is the essence of the opposition. Now, in our evidence, we also attached a confirmatory affidavit. Now, the reason for that was to deal with this concern. I call it concern deliberately, your worship, because as I indicated, there is no evidence to back it up. Now, the concern that the applicant will evade her trial is addressed by the fact that applicant has an alternative address. And one would not also lose sight of the assertion by the state with regards to misleading the investigating officer regarding her residential address. I think this point again was raised sharply by my learned colleague. There is just no way that by her providing residential address, she could be viewed to have misled the investigating officer. Misleading should actually be in the event that she gave a wrong address. She gave the right address. This is according to the state's case, an address where she last stayed in. Now she is saying, well and good, I'm no longer going to stay there. I've been in custody since April. If I am released from custody, I will stay in the other address which has been confirmed. What we do have now, your worship, is her version in as far as this address is concerned. This address has not been rebutted in any way by the state. In actual fact, the state has confirmed the correctness of this address. In as far as, in fact, they even attached a date that this person has been staying there since a particular year. But before then, the said person stayed in another address. I wouldn't go as far as dealing with other aspects which the defense find to be highly offensive to the character of the applicant and the person involved. But those issues were dealt with by Advocate Dlamini. So, your worship, then we have to deal with the point I made earlier of the character of a bail application. And in this instance, I'll refer this Honorable Court to State versus Viljoen. Your worship, this is a 2002 Volume 2 SACR 550. It's a Supreme Court of Appeal decision. In this matter, the court held that caution must be taken not to turn every bail application into a drawn-out trial. We can't have this bail application now being a trial before the actual criminal trial. It's not for this honorable court, it's not for this forum to determine the guilt or otherwise of the applicant. And the court in that decision also emphasized that it could not have been the intention of the legislature that bail applications would be a dress rehearsal of a criminal trial. As indicated, the huge emphasis that is placed by the state on regarding the charges and a plethora of other allegations on the evidence and on all of that, that approach, Your Worship, is offensive to the principle enunciated in State versus Atchison. And State versus Atchison, the citation in that matter is 1991, Volume 2, SA 805, NM 822 A to B. In this matter, Your Worship, the court emphasized that the bail applicant cannot be kept in detention pending his or her trial as a form of anticipatory punishment. The court pointed out that at the bail stage, the presumption of law is that she is innocent until her guilt has been established in a proper forum. It was held then that the court will therefore ordinarily grant bail to an applicant person unless this is likely to prejudice the ends of justice. Now, what do we have before you? Do you have any evidence to suggest that the ends of justice will be prejudiced if the applicant is admitted to bail? The answer is no. In actual fact, the applicant has demonstrated that the interest of justice permits her release on bail. This takes me to a point that I wish to sharply raise with regards to this application, and particularly with reference to the applicant. That a person may be in the public's subjective, and I'm intentional and deliberate about it, the public's subjective view, factually or morally guilty of a crime. But that view is subjective. And that view is not based on any legal grounds. Factually, morally, subjectively, a person is subjected to a court of public opinion. But that itself, that does not say that she will be proved to be legally guilty. There can be condemnation which does not talk to the essence of legality. And in a state such as South Africa, which is under the rule of law, only legal guilt counts. To convict a person in any other way will amount to vigilantism, mob trials, even anarchy. Not forgetting that a person will be found guilty in a court of public opinion, relegating the court processes and the rule of law to nothing but a process that would not seek to achieve justice. Your Worship, I submit as I conclude now. We have made a relief, and our relief in this instance is that the court, evaluating and analyzing the evidence holistically in totality, the state did not present evidence that establishes any of those aspects enunciated in section 64A to E. In the absence thereof, in their failure to do so, I submit, Your Worship, that, and in the event the court finds the schedule that the accused or the applicant is facing falls squarely under the ambit of Schedule 1, then the onus which would have shifted unto the state to prove on the balance of probabilities that the interest of justice does not permit her release on bail, that onus would not have been discharged by the state. Conversely, the applicant has demonstrated a very strong case in respect of her eligibility as a candidate to be admitted to bail because the dictates of the interest of justice demand so. That being the case, Your Worship, I wish to address the court on the appropriate amount that the accused will be in a position to afford. In our papers, we outlined her personal circumstances. The fact that she was running a company, a skincare company, and Your Worship, it's really regrettable that she didn't have the opportunity to really deal decisively and robustly with allegations contained in the opposing papers, including the allegations that she was disbarred or something to that effect by the Health Professionals Council of South Africa. Something that we would have dealt with sufficiently because there is proof to the contrary. That being the case, she has been out of pocket. She has not been generating any income for a period of more than 4 months now, since she's been in custody. It is thus our submissions that an amount of 10,000 in light of her personal circumstances and looking into the case at hand. But furthermore, one cannot resist the temptation to zoom into what happened with her co-accused. They were admitted to bail of an amount of 10,000. We are of the view that that amount of 10,000 rand is an amount that would be fair under the circumstances, that any amount higher than the one proposed would be tantamount to refusal of bail, that she is a correct candidate to be admitted to bail, and that bail in the amount of 10,000 rand should be fixed. Your Worship, this brings me to the end of my address. I'm indebted to court for allowing me to proceed and deal with these issues expansively. Your Worship, the defense reserved the right to replicate after the state submissions. I will pause for now. Should there be any issues flowing from my address, which the court would want to canvass and get clarity on. The defense is at your disposal to attempt to address some of those as a court basis.
Thank you, sir.
Yes, thank you, Chief. I'm ready.
Okay.
Let's swap seats, my brother.
Rather, we should cross the floors.
Yes.
Thank you.
I have been handed all the exhibits that was given to me on the previous occasion, and it appears that I made a mistake with regard to the marking of the exhibits. The affidavit in support of the bail application is Exhibit H as correctly marked, and then the affidavit of Mr. Flyman in opposing the application should be Exhibit I, so I'm going to amend it to Exhibit I. If you can do the same on your records, please. Which will then make the certificate of the DPP Exhibit J.
As a court basis.
As a business. Can I, then at this stage, request that the heads that already the court has already confirmed to have received also be marked to form part of the record?
It will then be Exhibit K.
That will be K. As if the court will bear with me, the state has to now reply or to address you on and to touch on aspects that have been raised by my two learned colleagues over 2 days. Yes, there are aspects that I wish to deal with first before I get into my written address. In fact, as I get into my written address, Your Worship, I will here and there briefly stand off my written address to address some of the aspects that might have been raised. Yes, at the beginning of these proceedings, both the state and the defense agreed that the applicant is facing, amongst others, charges falling under Schedule 5 of the Criminal Procedure Act 51 of 1977. This was based on the fact that the charges against the applicant include corruption in contravention of Section 3A and B of the Prevention and Combating of Corrupt Activities Act number 12 of 2004, and fraud which the state alleges were committed by a group of persons acting in the execution and furtherance of a common purpose or conspiracy. Let me pause then here, Your Worship, and address you on aspects that were raised in relation to the schedule. Indeed, the DPP has now since confirmed the schedule, but there are aspects that have been raised which, in my view, are misleading and not totally correct. And that relates to the charges, Your Worship. Let's look at count 3, that the defense allege is the sole charge that may speak to Schedule 5. And this they based on the fact that in the affidavit of the investigating officer said under oath that the applicant paid an amount of 85,000 rand. And therefore, in their view, the 85,000 rands falls short of the threshold, which is 100,000 rands, which then makes it a Schedule 5. Let us define what corruption is. The charge is very clear. Count 3 states, amongst others, that the accused in furtherance of a common purpose unlawfully and intentionally directly gave out or agreed or offered to give to any other person. Then it specifically states who the person in question is. In the furtherance of a common purpose, they offered a certain gratification, specifically to Teboho James Dipolo. Who are these people that act in furtherance of common purpose? Accused 1, 2, 3, 4, and 5. Now it goes off to say any gratification, to wit, to offer him 2.5 million and paid him 40,000 for the assistance to disconnect the cameras and recording, to help him to facilitate the escape of an inmate, and he specifically mentioned the name of the inmate, whether for the benefit of that person or for the benefit of another person in order to act personally or by influencing another person to act in that manner, then it counts. The assertion that this count relates solely to 85,000 is not correct. Even if there was not a cent paid out, corruption is complete. Once there is an offer or to accept any gratification, in this instance, what is the gratification? The gratification in terms of the charge is 2.5 million rand. The commission of corruption is complete. It is on that basis that the state is saying this indeed is a Schedule 5, because this offer or agreement is committed by a group of people in the furtherance of a common purpose. What is the common purpose? Is that Thabo Bester must escape. What is the gratification? 2.5 million rand. Corruption is complete. Even if not even a cent was paid by any person, corruption is complete. Then let us go to count 4. I must concede that when you look at the top, where it is written count 4, it says accused 1, 3, and 7. But for the reason unknown to me, that's where the defense ends. When one looks at what the charge is, what the charge is against the accused. It says, contravening Section 3A, read with Sections 1, 2, 24, 25, all those subsections of the Prevention and Combative of Corrupt Activities Act 12 of 2004 as amended. Corruption. Then it states, receiving a benefit. Then it lists the accused. It says accused 1, 2, 3, 4, and 5. Why they wouldn't read this into record, nobody knows. But the fact of the matter is, I concede there could have been, when one looks at the definition and what the crime is, accused number 4 is included. And what is the gratification in that respect? 2.5 million rand, whereby 40,000 rands was paid. Even if the 40,000 rand was not paid, the corruption is complete. We're talking of 2.5 million rand. But that does not end there, you see. Let's look at what count 14 says. Count 14 specifically says accused 4 and 5. Who are accused 4 and 5? Number 4 is the applicant before court. Number 5 is the person that the applicant says kidnapped him to Tanzania, which is Thabo Bester. What is the gratification there? The gratification is 105,000 rand. What was it for? To assist accused 5 to escape from G4S Correctional Center. Who was paid? Sinoe Matswara. Is it obligatory to state that when one has already said all these people, which is 4 and 5, acted in the furtherance of a common purpose? What is the gratification? 105,000 rand. Whether the 40,000 rand was paid or not, corruption in terms of our law, South African law, is complete. Those are the charges that, and the true position of our law that my learned friends turned around to fit themselves, to exclude the Schedule 5. But all these charges I have read out, and as confirmed by the DPP, are within the ambit of Schedule 5. Worship, let me state the following. When Advocate Dlamini was addressing you, %80 of his address, I would say, consists of a personal attack on the prosecutor and the investigating officer, going as far as calling us names, but I'm not going to address the court on that. But he went on to make a very serious allegation against the prosecutor, being myself, making me guilty of unlawful conduct, as he stated it, by amending the affidavit of the investigating officer. Worship, that is not true. Fortunately, this happened in an open court. The record is there. And fortunately, at that time I read out the affidavit of the investigating officer, I had already gave his affidavit to the court. So at that stage, that affidavit, which is part of the court record as we speak, was with the court, and it has not been amended in any way. But look what he does. He accused me of that unlawful conduct. And yet, he is the one who started with the unlawful conduct. The court will remember that he changed the numberings of the affidavit of the applicant and said, this is a mistake, this is a mistake. Not only one, but three. To say this must be regarded as a mistake. Did he now take it to the applicant to confirm and to initial that? No. And yet, and then let me address this aspect that he never placed it on record. What is that I changed from the affidavit? But let me remind the court what happened. I was reading out the affidavit. Granted, the affidavit, not numbering, but when I counted, it's on page 5. And I read, upon digging this grace, I read it into the record, and then I said to the court, I think this must read grave without changing anything. I still have it unchanged. The court has it unchanged. Did I change anything? No. And yet, he emphasized about this unlawful conduct and the unlawful procedure. Joseph, so much has been said about the investigating officer and the state. And Your Worship, I need to state insofar as that aspect is concerned, and I want to place it on record, that despite his reservations and his accusation of the conduct of the state, he did not object to the admissibility of that affidavit, despite him believing that the prosecutor has amended the affidavit, which I should not have. He did not. He had a right to stand up and say, I object to the admissibility of the affidavit. Coupled with that, Your Worship, even Mr. Motloung touched a bit on that the state has, or the investigating officer have appended a picture, the authenticity of which has not been proven. That was handed in as an exhibit, and it was accepted. The defense did not object to the admissibility of that picture on the basis of authenticity. It's only now in their address that they now state, they should not have done that. But look at them. In the confirmatory statement that they handed in, there's a copy of a bill from the municipality. Has that been authenticated? So the very same conduct that they accuse the state of, they commit the same thing. And they did not object even at that stage to say, we object to the admissibility of that. It must first be authenticated. That is what the procedure in this court demands. The third aspect I need to raise, Your Worship. Throughout their address, both of them, they've been saying the state has failed to prove 1, 2, 3, 4. the state has failed to prove this and this and that. What does our law say? The law. In Schedule 5, it says the following: notwithstanding any provision of this Act, which is the Criminal Procedure Act, where an accused is charged with an offense referred to in Schedule 5, but not in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless, and I need to emphasize this, unless the accused, not the state, unless the accused, having been given a reasonable opportunity to do so, do what? Adduces evidence which satisfies the court that the interest of justice permits his or her release. The duty is on the applicant to do what? To adduce evidence. What kind of evidence must she adduce? The evidence that satisfies this court that the interest of justice permits her release. This position, Your Worship, according to my written submissions, is reiterated in State versus Ruode, 2020, Volume 1, SACR 329, Supreme Court of Appeal. At paragraph 25, the court reinforced the principle that the applicant carries the evidential burden on account of Section 60B to persuade the court that the interest of justice permits a release. Not for the state to do anything. All what is reiterated here is the section talks to the accused, the applicant. As said, Your Worship, the onus is on the applicant to satisfy the court on a balance of probabilities that the interest of justice permit her release, that he should read her release. As correctly pointed out by Mr. Mutlou, Section 60, subsection 4, provides, amongst others, that the interest of justice do not permit the release from detention of an accused when one or more of the following factors are established. Then it lists A, B, C, D, E. The first, A, deals with the likelihood that the accused, if he or she were released on bail, will endanger the safety of the public or any particular person, or will commit a Schedule 1 offense. Advocate Dlamini, in his address, as much as I would have wanted to avoid mentioning them by names, but the fact of the matter is we have a situation where two legal representatives addressed the court on the same aspect. Therefore, to do the distinction, they will have to forgive me that I mentioned them by name. That Mutlou? Advocate Dlamini says, and I remember he even wielded the affidavit of the investigating officer saying, nowhere is he saying anything about Section 64A. What does the law say? It says, amongst others, that the interests of justice do not permit the release from detention of an accused where one or more of the following factors are established. One or more. The investigating officer could have, in replica, in opposing the affidavit, only have relied on one factor. In terms of the law, he could do that. Only one factor. Does not need all factors to be addressed. If he has nothing to tell the court about that subsection, why still include it? And where he does include, like the section 64C, where he does include, he's been criticized. Wow, 2 lines. Where he does not include, also is a problem to the defense. But what I'm trying to raise here, Your Worship, is that the legislature deliberately says where one or more of the factors have been established. And who needs to do that? The applicant, not the investigating officer. The applicant. Your Worship, both the state and the defense adduced evidence by way of affidavits. Neither the state nor the defense could challenge anything on the affidavits because they could not cross-examine. And therefore the court did not have the benefit to can make judgment on the credibility of any person. And yet so much has been said by both defense counsels about the credibility of the investigating officer, which is not challenged. At some stage, he was said to be decorating. What decoration? Your Worship, it is therefore my submission that the court will have to consider whether the applicant has discharged the onus that is on her to satisfy this court that the interest of justice permits her release. Both my learned friends, when they addressed you, they introduced evidence through a back door. They address you on aspects that cannot be found in the affidavit of the applicant or that of the investigating officer. As I go along, I will deal with those aspects. But one aspect that specifically Advocate Dlamini placed on record, it was in relation to the suspension of the applicant's membership of the medical council, which is in the affidavit of the investigating officer. When he addressed you, it cannot. In fact, the applicant, nowhere in his affidavit does she say anything about it, about the suspension. And yet, when Advocate Dlamini addresses you, Your Worship, he specifically says, the applicant informs me that I don't need a certificate to practice in the field that I was practicing at the time of my arrest. It's nowhere in the affidavit. He's the one who raised it. And yet, every aspect that the state or the investigating officer mentions in his affidavit, the court has been asked one and the same question. Where is proof? Where is that evidence? And in conclusion, my learned friend was quite correct, and I want to commend him for that. In conclusion, he cited a case law that specifically says the court must caution not to turn bail applications into trials or protracted trials. And that's exactly what they are saying the state must do. They say the state must prove all these allegations. They've been saying that from day one until now. And Your Worship, that is not the approach. It's about factors which are mentioned in the subsections that I have already hinted, which the court must then consider when deciding on the issue of whether it is in the interest of the applicant to be released on bail. Your Worship, my 4.2 paragraph, I state, on the other hand, in the affidavit on page 10, at paragraph 10.1, the applicant confirms that she has been informed of the charges against her and goes on to list these charges. Then she goes on to say at paragraph 10.3, she has been advised of a right to remain silent and not to reveal the basis of her defense, and that should she reveal the basis of her defense, it may be used against her at the ensuing trial, and as such, she decided to exercise and assert her right to remain silent and not to disclose the basis of her defense until the appropriate time and forum. Thus, acting on legal advice, she chose not to challenge the strength of the state's case. Your Worship, this being one of the factors for consideration, I'm happy that both my learned friends have touched on it, and therefore they are aware of what the law or the subsections provide when it comes to bail applications of Schedule 6. It specifically refers to, amongst others, the strength of the state's case. And in his address, Advocate Labini says the state's case is so poor. I wonder on what is he basing that? And the court shall remember that in the beginning, he told the court that the investigating officer, in the first 5 pages of his affidavit, has made a very nice story. He says, he calls it a story. But when you look at all those 5 pages, he is telling the court what the case against the applicant and his co-accused. And specifically, he made reference to issues that I believe are in the favor of the applicant. He himself, he raised it in his affidavit. For instance, at 5.1, he's the one who's saying the applicant is a married woman. And then he goes on to tell this court what the case is against the applicant and his co-accused. But of importance, because the defense says when the court looks at the personal circumstances of the applicant only, she has made the case to be granted bail. And they say that has not been challenged. There's no evidence before this court contrary to that. But let's look at the personal circumstances that the investigating officer stated in his affidavit, which the defense is silent on. They did not say anything about it. Amongst others, the investigating officer attached her founding affidavit that was filed in the High Court in Pretoria. For what reason? For the reason that she wanted the court, amongst others, to declare her as a customary wife of the deceased. At that stage, the deceased was mentioned as Thabo Bester. It's a customary wife. They don't comment, they don't say anything. And that is the affidavit that the applicant herself submitted to the High Court. And they say the state has failed to give substantive evidence or issues to show the charges. What does it say in 5.5? By the way, 5.5 is one of those 5 pages that we are told are stories. And this is, amongst others, showing what evidence the state will lead during trial. He says at 5.5, on or about the 7th to the 13th of April 2022, the applicant collected and claimed an unidentified body, which was unclaimed from State Mortuary in Bloemfontein under the false pretense that the body was that of her father, Zingiza Magaga. This is what the IO says he has when the matter goes on trial, and how, what role the applicant played. And then he goes on to say she then arranged for a funeral and burial of the said body in the early hours of the morning, citing cultural practice. And he goes on to say when he, the investigating officer, and the police dig the grave to exhume the body, they found rotten meat inside the coffin. He's giving us what the state case is against the applicant. And he says, during my investigation, that is now 5.6, I discovered and confirmed that the applicant booked into a boutique hotel in Bloemfontein during the periods 24 to 28 March 2022, 29 to 30 March, and 13 to 14 April 2022. One would ask, as time and again I hear that question, so what? She has booked into a boutique in Bloemfontein, so what? But what the investigating officer is showing us is that it is at that time that accused 5, during that period, that accused 5 escaped. According to the applicant, who is accused 5? Accused 5 is the person that kidnapped me. and took me to Tanzania. Have they addressed the court on that aspect of the affidavit of the investigating officer? No. Perhaps in replica, I'm sure. And then he goes on to say at 5.8, I'm saying on the 23rd April 2022, the applicant and accused 9 approached the mortuary at National Hospital Bloemfontein to claim another unidentified body. Is that not one of the charges that talks to an unidentified body? Let's look at the charge of defeating the ends of justice in count 11. And let's look at count 7, the violation of a body. Those are some of the counts that are there, and he is giving what evidence he has to prove those counts. And yet, we are told time and again, the state presented no evidence, nothing, on the strength of the state's case. And yet, the defense has not challenged this, what appears in the affidavit under oath of the investigating officer. They did not do that. Why? Perhaps it was focusing on how the affidavit was drafted and the like. But these have not been challenged. And look at 5.13. It is under oath by the investigating officer. On 5 May 2022, the applicant, together with accused 2, who is accused 2? It's her father, claimed the charred body found in cell 35 as that of Bester. And then it goes on to say, in claiming this body, the applicant submitted an affidavit dated 5 May 2022, commissioned at Polokwane to a G4S official, wherein she declares the deceased, and he puts it in inverted commas, to be her partner who has no other relatives. Is that not what the charge, does it not speak to the charge? Does it not speak to what case he has against the applicant? And then, Your Worship, in the latter part, the investigating officer start by giving the court all this to say, this is the case that I have against the applicant. Then he concludes by detailing the different charges and stating what evidence he has. For each charge, he will indicate direct evidence, what Mr. Tamini referred to, stroke eyewitness. This is the evidence that he says he has. And this is the evidence that the defense says, keep on saying, the state must produce. We are not busy with trial. We are busy here with a bail application, where certain factors must be considered. Worship, continuing with my written heads, disclosing at page 4, disclosing the basis of defense which she has a right not to disclose at this stage, and challenging the strength of the state's case are two different matters. They keep on saying, I've been legally advised, I have a right not to disclose the basis of defense. That's not the issue. Of course, I confirm. She has a constitutional right of silence at this stage. But that does not mean she must not challenge the state's case. She must not challenge the strength of the state's case, which is one of the factors that the legislation says must be considered. Instead of challenging the state's case based on the charges solely, she goes and gives us an account of her kidnapping. And then once again, Your Worship, let me refer, insofar as the strength of the state's case is concerned, what does our higher court say in that regard? Let's look at State versus Jonas. It's a 1998, volume 2, SACR 677, SCA, the Supreme Court of Appeal decision, where amongst others, the court says, to be successful, the applicant had to show by adducing acceptable evidence that the state's case against him is non-existent or subject to serious doubt. Not to address the court and say, the state has got a weak case, it's poor. What SCA says, the applicant must adduce acceptable evidence that the state's case is non-existent, as they contend. And as I indicated, Your Worship, challenging the strength of the state's case and exercising your right to silence and not to disclose the basis of defense is two different aspects. And Your Worship, let me also refer, Your Worship, is there in my written submission, page 4, State versus Koch, 2003, volume 2, SACR 5. It's also a Supreme Court of Appeal judgment, where at paragraph 11, the following is stated: the strength or weakness of the state's case must be given consideration in determining where the interests of justice lie for purpose of section 6011B. And it further goes to say, in that case, the state has either failed to make a case or has relied on one which is so lacking in detail and persuasion that a court hearing a bail application cannot express even a prima facie view as to the strength or weakness. The accused must be given the benefit of doubt and then must be released. Is that the position in this case? The investigating officer has given a detailed account of what the charges are, how the applicant is linked. Your Worship, in dealing with the circumstances around her departure, as I'm saying, I'm not sure if now somehow disclose the basis of defense regarding what, because she has not been charged there is no charge before this court regarding her departure to Tanzania. But nonetheless, okay, it's fine. Defense gives us an account. She alleged she was instructed and commanded by accused 5 to get into a vehicle and leave the premise to a destination unknown to her at the time. And at this stage, it must be remembered, or who is the accused 5? Accused 5 is the person that the investigating officer in his affidavit, which is not being challenged in any manner by way of evidence, is a person who was sentenced to life and who was supposed to be at G4S prison at the time. That is accused 5 that the applicant says kidnapped her. And in her application or affidavit, her address appears to be the address in Gauteng. G4S prison is in Bloemfontein in the Free State. Where and how they met, they decide not to reveal that to the court. And yet, they say, accused 5 kidnapped me. They do not reveal where they met, how he kidnapped her at all. Is it by gunpoint? Is it by knife? How was she kidnapped? If indeed we have to believe she was kidnapped. It is my submission that in this aspect, she's not taking this court into her confidence. And yet, the investigating officer is told, we are told, he's not giving evidence, he's not getting into detail of how the charges, and yet, that's what the applicant does. We do not know how she got kidnapped and where. Nonetheless, the investigating officer in his affidavit gives reasons why he does not buy into this story. He gives reasons. We are told that no one in this country, no one even in this court, can really say how she got into Tanzania. But what the investigating officer is saying, which they are not saying, is that anyhow she found herself in Tanzania, she did not use a passport, which is a requirement for her to get into another country. That has also not been disputed, not by evidence, and not even by their own addresses. That the passport was not stamped. How then do you find yourself in Tanzania having been kidnapped? They don't even say what, where, which border they crossed. And yet they are the ones who raised this, that this is how I found myself in Tanzania. The investigating officer, all that he says is, what I know is that he did not use a passport. And then Your Worship, Advocate Dlamini, when addressing you on the aspect that was raised by the investigating officer of a travel abroad, the investigating officer says, from a passport, he could see that she has been abroad 23 times, or she has traveled 23 times. And Advocate Dlamini says, so what? Is she not allowed to travel abroad? What's wrong with that? What he does not address is that the difference between her traveling 23 times or so abroad and this particular traveling that we are busy with is that in this instance, the passport was not used. In the other 23 instances, the investigating officer says there are stamps that show that she has been going. But in this instance, the investigating officer says, this time, she has not used the passport. What does that mean? It can only mean that she unlawfully crossed into Tanzania. How? By way of kidnapped. By who? Accused number 5. Do we have that? No. In her affidavit, she says the kidnapping took place on the 17th of March, 2023. And the investigating officer in his affidavit says they were arrested in Tanzania on the 7th of April, 2023. That means from the 17th until the 17th of March, 2023 until the 7th of April, 2023, the applicant has all along been with the kidnapper, with the person who has kidnapped him, because they were arrested, both of them were arrested at the same time, according to the affidavit of the investigating officer, together with another person from a foreign national. Worship, I state here at paragraph 4.3.3 that kidnapping is a criminal offense. And then Snyman described kidnapping as unlawfully and intentionally depriving a person of his or her freedom of movement. This is what the applicant says happened. And the investigating officer then raises an issue, Your Worship. He says, if that is the case, why did she not open a criminal case? That question of the investigating officer is answered by Advocate Dlamini. What does he say? He says it's the applicant's choice whether to open a case or not. It is her choice. And Mr. Mklong don't say it's a choice, says it's her prerogative. Let's zoom into this choice that she made. The choice she made is not to open a criminal case. That is a choice that we hear. It's not in the affidavit, but we hear that it's her choice. The applicant is kidnapped by accused 5. She says she resisted, she was overpowered, and the like. In other words, accused 5, in her own words, if we have to agree this, accused 5 take her away from her children, 2 children, denying her with that action the parental responsibility that she says she has over the 2 children. He takes her away from a medical practice clinic because she could not be able to practice while she was kidnapped. But He's taken her away from, he takes her away from that as a medical doctor. He takes her away from her siblings. Because in her affidavit, she says she still have parents and she still have siblings. And now she finds herself arrested now and applying for bail as a result of the actions of accused number 5. And Your Worship, you choose not to open a criminal case against this person. Now we hear that certain offenses they don't prescribe. She can still open case anytime in future. But so far, this is what accused 5 did to her. And she does not open a case. And the investigating officer says, despite the reservations that we now have with the picture that is attached, she has been coming to this court smiling with the same person that he says in her affidavit kidnapped her. I wish to concede, Your Worship, at this stage and correct one aspect. I'm not changing the affidavit of the investigating officer, but as a state, I wish to concede that what he says in the affidavit that there is no extradition treaty with Tanzania is not correct. Will that be used against him? I'm not sure, but it has not been addressed so far. But nonetheless, whether that treaty exists or not is neither here nor there. The application remains opposed. At paragraph 7.3, the applicant provides this court with family background. Amongst others, she states she has full parental responsibility and specific parental responsibilities and rights of her 2 minor children. These are the children that she left behind when she was kidnapped, and she opted not to open a criminal case against this person. And let's take it further, Your Worship. In her own affidavit, she's telling this court, I am challenging, amongst others, my transportation from Tanzania to South Africa. I'm challenging that in the High Court. Now, let's pause a little bit, Your Worship. She has been taken unlawfully by forced into a car to Tanzania. I quite agree, and I agree with my learned friend, that this matter is still being taken up on further on SCA. But so far we have judgments that remains until SCA changes it. But the point I'm trying to make is, Your Worship, you are taken unlawfully to Tanzania. The South African authority, I don't know who they are, they bring you back to South Africa, amongst others, to be with your children and to practice and go on with your practice as a medical ed. They bring you back to South Africa. And you go and challenge that. You challenge the fact that you were brought back to Tanzania, where you did not want to be. She did not want to be there. She was kidnapped, according to her own evidence. It's a right to challenge whatever action you see. But what does this mean? It means, allow me to remain in Tanzania. That's what it means. And we are told she has no desire whatsoever to leave South Africa and to evade trial. Let me address one aspect that relates to the personal circumstances that are before us. The applicant states that prior to her arrest, she was staying at a particular address, which is 22A 2nd Road, Hyde Park, Sandton. She was arrested on 7 April 2023. Prior to my arrest, Your Worship, I assume it must be prior to 7 April 2023 when she was arrested in Tanzania. Or let's accept for the purpose of this case, it was on the 13 April 2023 when she was arrested to face these charges. She says, prior to my arrest, that was my address. She does not provide the investigating officer with the address at the time of arrest. And now we hear, and we accept. It's in the investigating officer's affidavit that she was staying in this address and she left in March 2023, and the investigating officer, I don't want to decorate it, but says unceremoniously vacated the place where he was staying. It's crucial to say, at the time, she still provides the investigating officer with this address, well knowing she's no longer staying there, according to her own evidence. Otherwise, how would the investigating officer have known this address? And now here in court, she provides the court with an alternative address. She does not state in her affidavit if this same address that she will be staying, she also provided to the investigating officer at the time of arrest. She does not say so. Why not? And it's her choice, Your Worship, where she wants to stay. It's a choice. But having said, I have siblings, I have parents, why would you want to choose to stay with a friend and not siblings or parents? Now, at the time this address was given in court, the investigating officer, yes, verified in no space of time. Short, I think we adjourned for an hour, which Advocate Dlamini finds offensive that in short space of time he was able to gather what he has gathered. It simply says how advanced the South African police services are. But the investigating officer, this has not been challenged. Even in the address, the investigating officer says, I have established that this is the nationality of this person. he does not end up there. He says, one of the co-accused, accused number 9, is from the same country, the same as this person who she says she will stay with. The investigating officer does not make judgment on this aspect. No. All that he's saying is there in the affidavit. He says it is concerning the ties that she has with this particular country is concerning. He does not make judgment. And yet, he is accused of being xenophobic. What does xenophobia mean? It means a hatred or a dislike of a foreign national. Does the IO say here that he dislikes or hates them? No. All that he's saying is it's concerning that accused 9 has been a gardener and security officer, and now we are giving another person who comes from. That's all that he's saying. He's not passing judgment. It's there in the affidavit. And yet he is accused of being xenophobic. But of importance, Yoshi, of importance, the applicant provides this court with an alternative address, granted. The investigating officer states in his affidavit, which is not challenged, in fact, it is commended, said, so it means even after the rental, she was still staying there. That's what Advocate Lamini specifically said. But the fact of the matter is, there is this previous address. This is the address where she will stay. What does that mean in terms of whether the applicant has a fixed address or not? The fact that he provides an alternative address simply says, as we speak, not tomorrow, not yesterday, as we speak, she has no fixed address. And the investigating officer is saying what? He's saying her relations with these particular nationalities is concerning. And yes, he did not provide a tracker or evidence, but he goes on to say even a Mercedes-Benz that she was rented in her name was found abandoned in that very same country that I do not want to mention. I might be accused of one or other thing, but I'm not mentioning it. But it's there in the affidavit of the investigating officer. So, Your Worship, all that I'm saying to the court up to so far is that the applicant has not satisfied the court in adducing evidence that it is in the interest of justice that she be admitted to bail. And that relates to section 60, subsection 4, B, which incorrectly is being said that that's the only ground upon which the investigating officer is opposing bail. Worship, moving forward, insofar as section 64D The investigating officer states in his affidavit, there is a likelihood that the applicant, if released on bail, will undermine and jeopardize the objective of the criminal justice system, including the bail system. And when one looks at the grounds, the factors that the court must consider, whether this has been satisfied or established, is the question whether the applicant provided false information, issues like that, which we find in the affidavit of the investigating officer. Factly, he says the fact that she provided me with this address, knowing she no longer stays there, she was misleading me. She provided me with false address. And he goes on further, Your Worship. Provides a list of false information that the applicant made not at the time of arrest, but previously when she approached the High Court in Pretoria. In terms of her own affidavit, although the name does not appear, she states that she is married with 2 children. And in the High Court, we know her to be married to Thabo Bester, which is accused number 5. And not only that, the investigating officer states that, amongst others, she says, under oath, which was commissioned before a legal firm of attorneys, that Thabo Bester's mother is deceased. And the investigating officer says, I traced her mother, his mother, and Thabo Bester's mother is alive. And we went further to conduct DNA, which is positive that this is Thabo Bester's mother. If one can deceive the High Court, what more about this court? Can this court really trust and conclude that it is satisfied that the applicant will stand trial, having gone to a High Court to claim a body, claiming that body belongs to someone who we know by now is alive, is accused number 5. He's alive. And the investigating officer not only stops there, she says the applicant has established that the applicant, when claiming this unidentified body, she said it was her father. Can that be true? We know accused number 2 in this matter is her father. And her father is alive. Why would you deceive? And that is the evidence that this investigating officer says we have. In relation to what? To fraud. She goes further than that. This is just trying to show the court that there are factors weighing against the release of the accused, the applicant on bail. According to the investigating officer, even the founding affidavit is there. That was submitted in the High Court in Pretoria. She claimed her father, which is accused too, negotiated lobola and that 60,000 rands was paid and therefore the customary marriage was complete in terms of her own affidavit in the High Court. Who is the father? Accused number 2 in this matter. That the investigating officer also says accompanied the applicant to claim one of the bodies. That's in his affidavit. She goes on to claim that Thabo Bester's uncle by the name of David Magagula is deceased. And the investigating officer says, I have established from one class Magagula that there has never been a David Magagula. Lordship, insofar as Section 64E, the investigating officer states in his affidavit the likelihood that the release of the applicant will disturb the public order or undermine the public peace or security. In this regard, we are told that this cannot be correct because her co-accused has been released by the High Court and there has not been any public outrage. But I wish to state, Your Worship, the conduct and involvement and the role played by the applicant as outlined by the investigating officer clearly shows she has no respect for the criminal justice system. She orchestrated the escape of a person convicted of serious offenses and who was locked up at the maximum security prison. It is a demonstration of a disregard for the courts and the law. Let's remember that Thabo Bester was sentenced by a court of law. Then someone went to claim that she is deceased and he wants to cremate her, when in fact Thabo Bester was alive. That is a person who has disregard to the processes that led to the conviction and sentencing of accused number 5. Joseph, the fact that her co-accused have been released, in releasing the court, considered specific personal circumstances and whatever, and the role and everything. It took everything into consideration. The circumstances, the role, and the personal circumstances of the applicant here are quite different from each one of those accused who have been released. Therefore, the court cannot just on that basis say, okay, your co-accused have been released, I therefore also release you. The court must still apply its mind and the court must make a determination whether evidence has been adduced to satisfy itself that this applicant, not the others that have been released, this applicant, it is in the interest of justice to release her on bail. So that comparison, we have not even been told what factors the court considered in releasing them. We are dealing with this evidence before us that relates to the applicant. Your Worship, my written argument, page 9, concludes by making reference to State versus Miselo 2002, 1 SACR 49 constitutional. See, where the court concluded that the release of appellant will disturb the order or undermine. In that instance, the charge was a mere possession of firearm and attempted murder. Your Worship, the court must take the holistic evidence before it. The investigating officer has mentioned in his 5 pages, which are said to be stories, how Thabo Bester, how the orchestration of the escape of Thabo Bester happened, and the fact that he was incarcerated at a maximum prison. And he says in this affidavit, the mastermind was the applicant. So those circumstances, Your Worship, are the reason enough to be saying, with this that is before me, with the fact that a sentenced person for life is released, and the applicant has a role in that, and she even went to Tanzania. None of the other co-accused, there is evidence that they were also kidnapped and taken to Tanzania. That's why I'm saying the considerations and the factors in this case are different from the other co-accused. None of them was there anything said, even when one looked at the judgment of the High Court, that they crossed illegally or unlawfully without passports to any of the countries. Therefore, it is my submission that the court cannot, solely on the basis that the co-accused have been released, therefore, the applicant must be released. Your Worship, the investigating officer, in his affidavit under oath, provide the court with reasons why he believes the bail conditions should not be considered. And he substantiates on that aspect. Your Worship, the very same investigating officer that is being attacked personally and said to be decorating his affidavit mentions a factor which I believe is favoring the applicant. He lists the businesses that the applicant appears as a director. He lists them. In other words, what this means is, he is saying to the worship, amongst others, consider that she has businesses, which therefore I would have expected the applicant to be saying, Your Worship, one of the reasons I asked the court to release me on bail, I need to go and take care of these businesses of mine. But Advocate Lamini says, so what? And the state is showing the court that the businesses are at different addresses. Indeed. But one wonders, because we are told these are the personal circumstances. He's a medical doctor. One wonders, because that is not being challenged. If she has these businesses that she has interest in, that she appears as a director, Why would she not disclose them in her own affidavit? Why conceal that factor? What is the reason? Because, as I said, it should be a factor that works in her favor. But she conceals it, does not refer to it anywhere. Worship, insofar as my written address, it is my submission. The investigating officer, the prosecution, the state does not carry the burden of showing or proving to this court that the applicant is not entitled to bail. She must first show the court that this evidence before the court are good enough to admit me to bail. Your Worship, when one looks at the two affidavits, the evidence that is before you, I'm glad that Advocate Dlamini referred to the applicant's affidavit as a simple and straightforward affidavit. That is not what the law requires. It says, adduce evidence, not simple, adduce evidence that will satisfy the court that is in the interest of justice that she be admitted to bail. On the other hand, the affidavit that is criticized is extensive. And nothing in that affidavit shows, like the impression that Advocate Dlamini gave, that the investigating officer harbors any hatred or whatsoever against the applicant. He simply gives the court what his investigations are, what the charges are, what evidence he has. For instance, he says, I have since established from the bank records of the applicant that she paid 85,000 rand. Now, to accuse number one, the defense is saying, in fact, let me start this way. The court should be mindful of the fact that we are dealing with one accused here, which is applicant number 5. And therefore, the affidavit of the investigating officer and the investigation and the background she gives us about the applicant relates to the applicant only. And therefore, it could not be expected that he goes to an extent even saying what the other accused did. We don't know what the other monies came from and whatever, and we cannot say it here. All that he did, he zoomed into what the applicant only did. There are other amounts. Your Worship, as I indicated, I will also ask the indulgence of the court. There has been so much that I noted from the addresses of the two learned friends, and I request that we adjourn so that I go through and don't waste time in addressing the court on what I have already addressed, just to identify those that I need to touch on. I don't know what time is it. I see the court personnel are happy that we did not break for lunch. They are happy, but can I ask that maybe for 30 minutes, 2:30? Then I think I'll take about 10, 15 minutes and then I'll wrap up. 2:30, Your Worship? Is that okay? Is that okay?
That's in order, Your Worship, as the court pleases.